This is the Wise Guy Radio Show, a podcast dedicated to educating and inspiring through conversations with today's top talents in the world of glass. We will be dissecting their journeys in hopes to deliver actionable content that you, the artist, can start implementing now, helping you grow not only as a creative spirit, but also a successful artistic entrepreneur. With a little organization, relationship building, and your artistic ability, you can obtain greatness. Climb aboard, whether an artist, retail owner, or enthusiast. We have a ton of fun in store for you. Welcome to the Wise Guy Radio Show. This episode is brought to you by Mountain Glass Arts. Mountain Glass now has their December sales running from now until the end of December 2015. You can now get borosilicate AccuGrind joints for 15% off by putting in code AccuGrind, that's ACCUGRIND at checkout. And they also have their Soft Glass COE 104 sale, jewelry making essentials for 25% off. Just put in the word jewelry at checkout. That's JEWELRY. Just go to mountainglass.com for more information. And this show is also brought to you by Green Flash Glass. And Green Flash Glass is now offering 10% off all sales from now through the end of December 2015. If you are a wholesaler, retail store, get a hold of them through their website at greenflashglass.com. Give them a phone call and place your order. That is greenflashglass.com. And all sales are always free shipping that are $1,000 or more. And now on with the show. Hey, what's happening, all my brothers and sisters? Welcome to the Wise Guy Radio Show, episode number 64. This is Jay Michael, your host. Thank you so much for tuning in today. I am excited to be here as we have an awesome show with our repeat guest, who is Luke Zimerman Esq, a lawyer out of California, specializes in our industry of functional glass art and also the cannabis law industry as well. And we are going to be talking about trademarks today, and definitely y'all want to stay through the entire episode because this is super important information and great insight into how you can protect yourself as an artist and cover your names and brands and everything. So definitely listen all the way through in this one. And also, another thing I want to say is that next week I am going to be starting my weekly giveaways, which will have to do with the show. And something that will be said in the show today will be an answer to my question next week for you guys. The questions will basically be coming out every Wednesday, and they will be pertaining to one of the three shows during the week. And, it's my little trick to get you guys to listen all the way through, but also because I love you guys and I'm thankful for being here and grateful and want to give somebody something weekly. Because I like giving away things. And so, therefore, I'm going to be doing a little quiz, I guess you'd call it. And also, some quick other housekeeping here for everybody is that Mountain Glass Arts has their Get It Quick sale, and this is a extended Get It Quick sale. It runs from December 9th through December 15th, which is the day before my birthday. And right now they're offering Chinese color and clear rods and tubes for 40% off. All you need to do is use coupon code CHINESE, that's CHINESE. And then also for all of you soft glass lamp workers out there, they are having their 30% off Creation is Messy sale, which I guess is a ton of glass. I'm not really familiar with that. But anyways, just put in the code MESSY, MESSY, and you will get 30% off of their stuff. And now they are announcing that they are now carrying odds and second quality glass from TAG, which is Troutman Art Glass. And as we all know, we love the colors that he produces and previously produced that are now still being made. And now you can, for the first time ever, get this sale. So just go to mountainglassarts.com or just mountainglass.com. And you can find their sales on there. Remember the codes. And, so there you go. Take full advantage. This Get It Quick sale runs again through December 15th, 2015. So if you're listening to this next year, never mind. Don't listen to this. So anyways, guys, So a couple more things I want to let you guys know is that starting in January, myself and Chad, who is my shop mate / shop owner, business mate, what have you, we are going to be offering private classes in our studio, everything from the very beginning intro into glass lampworking, all the way through specialized 3-day classes, whether you want to learn how to make animals and creatures and critters, work on figurative sculpture, hand-blown, whatever. We are going to be designing classes specifically for certain areas for those of you out there that are also intermediate and experienced glass artists. Now, I'm not going to say I know everything in the book. There's lots of other artists out there that know a lot more than I do. But I just know that with myself and Chad's experience, that we both have, I guess, like almost 30 years now between the two of us under our belt. And with my background that I have with Disney and the stuff that I've learned there in terms of sculpture work and consistency, as well as the background that I have just in the 17 years of production and studio work for myself and for distributors, I figured it was time for myself to branch out, and Chad's all about it as well. So just stay tuned for that. If anybody's interested now for the info, we do have a lot of it already taken care of. You can send me an email, and that any kind of question you guys may have, you can send me an email at info@wiseguyradio.com, and I will get back to you ASAP on that, and I can forward you the information with the price breakdown and what the classes are going to be all about. And other than that, stay tuned for the newsletters. Those who have not subscribed, you can just go to wiseguyradio.com and go down to the bottom of the page and just subscribe to our newsletter. Therefore, you can get insights into the shows, some behind-the-scene looks, special coupon codes and discounts, and also some updates on our sales on Etsy and our Instagram auctions we're going to be doing. And, yeah, so there you guys go. Again, thank you so much for tuning in. I hope you guys do take this to heart because this episode is so important, knowing how to protect yourself as an artist, whether it comes to your brand and kind of concepts of what you are, your property rights to yourself. So you guys enjoy, take care, and we will talk to you on Friday, where we will be getting into a little glass knowledge with my boy Shane Penn. You guys take it easy. Love ya. Peace. Hey, what's up, everybody? We are back with our law segment, talking about trademarks and copyright laws and all kind of fun stuff. And it is a pleasure to bring Luke back on the show. How's it going, Luke?
Good. How are you doing today?
Pretty good, brother. Thanks again for coming back on. If you guys haven't heard Luke's episode, he was episode 30. It was one of those scare the shit out of you episodes because of the stuff we talked about and the reality of where we are still in this industry and stuff we all need to really know about. So it's pretty cool to continue doing this, man. And again, thank you so much for coming on board and helping us out here.
It's a pleasure to be here. I'm really happy that I'm able to provide some knowledge to an industry that I really love and appreciate.
Heck yeah. So we are going to be talking about trademarks today, and I know you and I have in the past talked about copywriting or trademarking logos and names of businesses and even maybe lines of work as well. So I'm really curious to see what kind of stuff you got to talk about and see what we can fill in the blanks here and some of these questions that people have out there.
Yeah, trademarks, especially for the glass culture, are becoming more and more of an issue. I think I've seen a number of more disputed name usage. I've seen more cease and desist letters. I've seen cease and desist letters come from non-glass industry coming into the glass industry, especially if people recreating more traditional products in glass, and a lot of problems stemming from Instagram in that regard, where if you use the wrong hashtag, especially of a trademark product, you're going to find yourself having a problem.
Yeah. Yeah.
So I'd like to think of this episode as really addressing trademarks in both a proactive way of protecting yourself and protecting potentially your trademark, but also being aware that how you're marketing your products could be opening yourself up to liability of a trademark infringement, where you think, this is something fun, or I'm making a sculpture, or I'm playing up on a brand that already exists. There's a possibility you're going to find yourself getting a cease and desist letter from companies that have more money than you do and are willing to squash anyone who's using their trademark without consent or without permission.
Yeah.
So
yeah, it's fascinating. So just kind of real quick, one question I have before we kind of get into all this. So if I was to create a trademark item in glass and I didn't sell it, I'm good to go. But once you put it out there in the market is when you start to have issues, basically, right?
Before I answer that question,
okay.
This is a perfect segue for me to say this.
Okay, perfect.
I am not representing anyone who is hearing this podcast. I'm a licensed attorney out of California. Any of the information that you're going to hear me discuss in this podcast is merely my opinion. This is not a legal opinion. This is not something you should rely on. If you feel like any of the issues that I discuss or any of the information is something that might apply to your business or you personally, seek out the representation of an attorney. I am not incurring any liability from this. We are not having an attorney-client relationship, and just listen to this for entertainment, and if anything comes up, we'll go from there. In my opinion, if you create something that's trademarked, and so long as you don't put it into commerce, you're not trying to generate some sort of profit from it, I don't think you have a problem. It's no different than creating art for your own personal appreciation, your own personal satisfaction. It's something you're not trying to monetize and derive gain from. And the idea of a trademark is protecting something. It's kind of a twofold. It's one, protecting a consumer so they know the point of origin for a good or service, and they know that they can rely on it. And then two, protecting a business where going ahead with a business model, a product, or offering a service, it can protect the business because it identifies the product or the service that the business is providing and restricts other people from using the name, which might cause confusion to their consumers. So if you're making it for your own personal appreciation and you're never selling it, I think you're more in the direction of not having an issue. Where this would get interesting is you make it for your own personal appreciation, but now you want to display it. And if it's being displayed and there is some amount of financial exchange to see the goods that you've made, you're actually engaging in a commercial transaction then.
Okay.
So it's not just a yes or no, but if it is just for you to have at your house and appreciate for yourself, I don't think that would have as much of a problem.
Cool. Yeah, it makes total sense.
Yeah.
Awesome.
So the way I would like to break down this episode too is when looking at a trademark, there's 4 things that you really need to consider. 1, is your trademark protectable? 2, is it already in use? 3, can you get your trademark registered? And 4, special concerns we might be seeing for pipes and trademarking. Trademarking is not new to the glass and pipe industry and culture. Many of you might not be aware of this, but companies like Mothership, Hitman Glass, Swiss Perk, Graphics, all have federal trademarks, or at least applied for federal trademarks. While it's not glass, most of us are familiar with raw papers. They also have a federal trademark. So these are being pursued by a lot of really legitimate aspects of the industry. And in my opinion, it is the future, especially if you're developing a brand, that you want to have protection for it. So moving ahead with that is essential. You get common law protection just because you're using it, but really that doesn't amount to a lot of protection. So federal registration is ideal. That's something for, I think, every artist to consider. I made this comment in the last episode, and I think it's still applicable, especially applicable in this episode.
Yeah.
The aliases of the old days that allowed us to move through the industry more anonymously have become your trademarks. They are, in many ways, the way consumers find you. They are the brand identity that you have. They are having more so than even just the name. It's the feeling, the lifestyle brand, however you want to call it, surrounding what that name is. And consumers gravitate towards products based off of that. So if you've been operating under an alias, consider looking into this. I think it's important. And actually, one other glass artist who has multiple federal trademarks is Chihuly.
Yes.
That he even has his signature trademarked.
Right.
That I think, especially for any glass artist who understands the value of what that means and hopes or aspires to grow to a size that would be comparable, it's just, this is part of doing business. So
yeah, I agree, man. When I was working the Chihuly collection here in town, I studied a lot of his business practices in terms of his marketing from the very, very beginning. Because from what I understood, he didn't actually sell like a major piece of work for like the first 13 years or so in his art career.
Oh, wow.
And then once he did, I guess the story that I heard is kind of off completely sidetrack is he had a show opening, nothing sold, so he went back in there and added zeros to all the items in there, and then they sold within that month. Kind of crazy. So, but through that process, he learned, like, I'm going to go across the street from, if there's two galleries across the street from each other, he's going to go to both places and say, hey, I'm not signing your forms, you're going to sign my forms, and you guys can both kiss my ass if you don't want to sign it, because I'm going to sell to both of you or none of you at all. What do you guys want to do? And usually both places would pick his work up because it became more popular and everybody wanted to have his glass in their places. It's kind of a interesting, way he worked his whole concept and his trademarks and his names and his branding. I mean, now he's a brand, he's Chihuly.
Well, and that's it. As the name grows, the value of that trademark just increases. And that's oftentimes when you think about the valuation of major corporations, about where the actual value is for like Coca-Cola. You're going to argue, well, they own factories that produce these things. They own chains of distribution. They own apparel. Really, arguably, the most valuable aspect of Coca-Cola is the name Coca-Cola.
Mm-hmm.
Because you can put it on anything and you'll have consumers buy it because they identify with the brand. That is an incredibly powerful aspect, and it's their trademark.
Yeah, exactly.
And I think Chihuly has that same experience where, you start out as an artist, nobody knows who you are. And after you start getting that growth, people will gravitate and buy your goods just based on the name. And as people start buying these, especially in the art world, you can start adding zeros onto your work and they only get more desirable. And I think we are seeing that in glass culture now. I think especially in Colorado, there's a lot of great examples of high dollar pieces moving that are really based off of identifying with an artist's name.
Yeah, man. On that same note, it kind of came to my head here. I want to cut in if you don't mind.
Oh yeah.
On the whole Coke brand. So like, anybody asks if you want something that's bubbly and sweet and carbonated, whatever soda, you say you want a Coke. No matter if it's Coke or Pepsi or Mountain Dew, it's like just like the way that brand has come into our language and our culture on a daily basis. Some places it's pop, some places it's soda, but down here in Florida, we say a Coke.
I was going to say, that is very regionally based.
Right.
And actually, that touches on a very interesting dilemma in trademarking. Because Coca-Cola, and this is actually the first section we're going to talk about, is it protectable? And I'm going to use it as the example. So let me explain this concept really quick. Is it protectable? When you assess, and the United States Patent and Trademark Office, their officers will do this when a mark comes in. They'll assess, does it rise to the level of being a protectable trademark? And there are 4 identifiable categories to assess this. They're called fanciful and arbitrary, suggestive, descriptive, or generic. The most powerful protection will come from fanciful or arbitrary. An example of this would be Apple computers. Prior to experiencing the product, if you just saw Apple, you'd have no idea what that was. But as soon as you experience Apple computers one time, as soon as you hear Apple, you're going to have that association. Mm-hmm. Now you immediately think of the fruit, but you're also thinking about the computer. Prior to you experiencing that product, you didn't have that association. It was totally arbitrary. The name does not give any reflection of what the good or service the company is doing. Why this is really exciting for the glass culture is most aliases or most names used by glass artists, you'd have no idea that they were glass artists.
Right.
Ghosts, Salt, you don't know. And that actually is one of the best ways to seek trademark protection. Your chances of getting it granted are really high. The second level is suggestive. An example that's used by the USPTO is glance-a-day calendars. Now, Coca-Cola would fall into that realm where there's cola involved. You've had Coke, they might have come up with that. So Coca-Cola, it's suggestive. We know what the product is. Descriptive, arguably Coca-Cola could have been descriptive. That's the third category. Fourth category is generic. So Coke has to be incredibly diligent policing their intellectual property and the use of their trademark, because if a trademark gets used to the point where it is just common speech, it's not protectable anymore. Even if it was arbitrary or fancy, it can revert down into being generic, which is a very nuanced area of trademarking. But the best example is Xerox, where Xerox is a copy machine. And really, we got to the point where we were just saying, oh, would you Xerox this for me? Even if we weren't using a Xerox machine.
Right.
Yeah. Because it became so commonly used, that made it generic.
Well, yeah. Oh, sorry. Go on.
Oh, no, it decreased the value of the protectability, not the value, the protectability of the trademark.
Okay. Well, that's why I brought it up, because just got me thinking, like right now it's a silly fad trend thing going on, but Q-tips, are being used, and Q-tip jars are being sold for thousands of dollars. But they're using the term Q-tip jar. Now, we all know Q-tip's a brand, but what you're supposed to use the thing for is not to go in your ear, but whatever, that there's all kind of weird shit. But what they're using it for in this industry, obviously, is to clean out a nail or something like that.
Right.
So that kind of correlation of the legality side of things, along with also now you're using a trademark name that's still a generic term being used for something that is cotton on both ends of a stick, So that's what I'm thinking. It's like, how do you run along that? Can they sue you for saying, hey, I'm using this container to hold your product that's being used for something potentially illegal, depending on where I live in this country? It's crazy.
Q-tip has gone the way of Xerox, where it's become so common that it's much harder to protect. I mean, people will buy Q-tip brands over other brands of cotton swabs on the basis of name recognition, but trying to protect that, because now all cotton swabs are Q-tips for us.
Exactly.
We use it interchangeably. The protectability of that has gotten really problematic for that company. It's one of these things where you can become so successful or so prolific with your product or service that everybody just uses it. I mean, Google fights with this all the time.
Yeah.
Because, hey, why don't you Google that?
Yeah, exactly.
Well, really, you're searching on the internet. You're doing a web search. That's the actual function of it. But they've become so efficient with their product, and we've relied on it so much that we use it for everything. You might be using Firefox, but you're still Googling something.
Yeah.
Just because it takes on its own meaning. I mean, so that's something you got to be aware of. I don't think we have anyone in the glass industry that has gotten so, I mean, for a period of time, arguably back in the day, graphics, when there was just the boom in pipes and accessibility, graphics really had a good chunk of the market. Where, at least for being in Wisconsin growing up, you just assumed that if somebody had a tube, it was probably a graphics. There just was not, they were a step above generic, and they were just the most identifiable brand at that time.
Yeah.
But I can't think of another company right now where you've just gotten so used to saying, give me your pipe, I can use this interchangeable word that is actually a trademark. And I don't think we haven't seen that yet. That might happen in the future. I mean, if somebody can.
Well, go on, sorry.
Oh, no, go ahead.
I was just thinking with the whole graphics thing, it reminds me with them, because I remember when they were shut down, whatever years ago. And then from what I understood, the law said, in a sense, that if you called it a graphics whatever water pipe, they called it a bong, which they made it fairly illegal because it had the bong word. And so that term graphics, if you're saying it now, that's the first time I've heard that name, dude, in probably 10 years, just because it was one of those things that people just stopped using it because of that. Like the K2 shit. There was 100,000 different models and brands out there, but if you referred to this stuff as K2 and it was an undercover person, you were going to get arrested because if you're purchasing something illegal.
That would make sense. So I guess then we can say we have seen this concept in the pipe industry, but in a negative connotation, where the trademark name graphics immediately was associated with an illegal activity.
Yeah, exactly.
But yeah, they still have an active trademark. I mean, I don't know what their market share is, but they still have a registration with that great Joker skull gesture hat that we all are incredibly familiar with.
Yep.
So okay, that's the first thing to think of is your trademark possible to get registered? Think of those four categories: fanciful, suggestive, descriptive, and generic. The second thing that you need to consider if you're going to try and register a trademark is there a possibility of confusion? This is not a clear-cut test and is done by a case-by-case basis and trademark by trademark basis. The USPTO examines every application for compliance with federal law and rules, and the most common reason for refusing a registration is likelihood of confusion between an already registered mark and the mark that is pending application. Now, confusion is determined by if the marks are similar, the goods and services of the parties are related as such that consumers would mistakenly believe them from the same source. The similar marks or related services by themselves are not enough to support a finding of likelihood of confusion unless a court has held that the mark is actually a famous mark. Each application is decided on its own facts. There is no simple mechanical test when used to determine whether a likelihood of confusion exists. So I got that directly from the USPTO. That is their interpretation is we know confusion when we see it. And
makes sense.
How that gets resolved in many ways is attorneys arguing back and forth and appealing to the USPTO of saying my client is not engaged in something that would be confused with this already registered or existing mark. Points that they use for considering confusion: the sound of the mark, the appearance of the mark, the meaning of the mark, commercial impression of the mark, similarity of the mark, such as city woman versus city girl. That could be possibly confusing. And then if there's similar classes or goods or services. So that's something you need to consider if you're going to register a trademark, is you need to be aware of if you're picking your name because it is playing off of a pre-existing name outside of the glass culture even, you're running the risk of getting one not registered now. But if you become higher visibility, you become more successful, you're running a risk of getting a cease and desist letter.
Yeah. Interesting. Now, if you say register and they deny your registration and you still use that name unregistered, is there going to be like a flag raised in a sense? Do all denials get a flag raised to make sure that you're not going to actually use that name for potential?
No. It's more so the USPTO. They won't police you. It is up to the independent entities. So this is the other thing. If you register a trademark, you have to protect your mark. You have to take the steps to do it. The USPTO won't do that. They'll give the decision of if the mark is registered or not.
Right.
And if the mark is registered and you do go into court, so saying I have an unregistered mark and I go into court and the other party is saying I'm infringing on their mark and they have a federally registered mark, there's already a presumption of ownership on their part. I have to prove that I've been using the mark longer than they have in order to show that I have a right to use the mark. And that, I just had the NFL pop up on the background. Weird. Sorry.
It's all good.
So the benefit of having the registration is when you're in court, you get more protection. And it is easier for you to police your mark because if you do end up going into court or when you write a cease and desist letter, you can say, here, I have this registration number. This is what the protection that is presumed that I have. You would have to show that you have some legal right to use it. Furthermore, I can now seek statutory damages for your infringement. And that's where the big money is. I mean, that's where you're going to find people going bankrupt for having a statutory infringement, or worst case scenario, or a lot less worse than going bankrupt. You find yourself in a situation where you've been operating a business for, we'll say, 3 years under this trademark and under this name, and now you realize I can't use this anymore, or I am going to have to pay statutory damages. And so now you got to look at your consumers and say, well, buy my product. I went from being something and now I'm brand X. I'm this new brand. Yeah. You should still buy my product. I know you're going to love it. Most consumers don't hang out like that. They don't keep purchasing like that. That's not how people move in the market. So
yeah, that's true.
That's something that's a very serious issue, though. Possibility of confusion is something that you really need to consider when you register a trademark.
No, something on the same lines, like the whole poor man copyright, poor man trademark thing, where you like mail it to yourself immediately once you design it or come up with it. So you always have it, in a sealed envelope, stamp dated, blah blah blah. So say like you did that, you never registered it federally. Someone else registers it federally. They take it to court. Does something like that hold up, or is the trademark, the registration, hold more than a stamped envelope?
So what you'd find yourself in a situation of is if you would beat them on the date, right? So you can prove that you were operating your trademark prior to their registration of a trademark. What they would not be able to do is they would not be able to stop you from using a trademark, and they would not be able to seek statutory damages. But what you would not be able to do is expand your trademark. You would have common law protection in the region that you're already operating. Also, you're going to have to explain to a court why something that is so valuable and essential for your business, you didn't take the steps to protect.
Yeah, makes sense.
And try to argue either I didn't know, I didn't care. None of these arguments really give a good impression that you care about your business and that you're operating with best business practices. So yeah, you would probably be, I mean, there are cases that I think there is an area in Africa, there's a country in Africa that McDonald's got late to the game of filing for McDonald's. And there was already a fast food chain or a burger chain operating as McDonald's, and they were denied because and I think they just took it on the chin and they said that they weren't going to operate. There's famous stories or famous trademark cases, even more locally, of someone operating a McDonald's in America, who the guy's name I think even was Ronald McDonald, and he had been operating as just a small family business for years. And they tried to shut him down, and he was still able to operate. He wasn't able to expand his business, but I don't think that was his business model anyhow. He just had a small family business. But so if you're already using it, and that gets into another interesting one. If you're using your last name, you do have a limited right to use your last name in your business. And if it happens to share the name with a famous trademark, you can't get shut down as easy. But also, I would never recommend a client doing that, because depending on how you want to operate your business, if you want to grow your business, that's not a great way to do it. Let alone if you're picking a trademark that you already know has a market presence, especially a pretty significant one. I recommend all my clients don't do that.
Yeah, absolutely.
Yeah. So the third issue, will you get it registered? This one, there's a little bit of a technical side, which if you are at a point in this where you're considering getting a trademark registration, go speak with an attorney. I have seen a number of issues come across my desk where someone goes with an online service that says they'll file their trademark for them at a discounted cost. You don't need an attorney. You can do this on your own, or we'll take care of it. And the quality of what the filing looks like is terrible. It's garbage. They submit a specimen that is barely readable. There will be issues with how they do the category, with how they do the description of the service of the product. And inevitably what happens then is you get something called an office action, which asks for a clarification of what the filing actually meant. And if you've used these services, you go back to the service and say, hey, I got this letter. Apparently my trademark isn't registered. What do I do next? And they say, well, you paid for us to register your trademark. We're not actually attorneys. We're not going to respond to your office action for you. And the federal government doesn't refund application fees. So now you're in a position where you've paid for a service, they've registered it, you're not getting your money back, and you don't know what to do. They don't tell you how to fix it. So if you would have started working with an attorney, it might be a little bit more expensive at the beginning, but you'll get the full service of, okay, here's what we do next. Here's how we amend your application. Here's how, and if you're familiar with trademarking, some people are. I've met people, especially in the design world, seem pretty familiar with it. And you feel competent, do it on your own if you feel that way. But if you get to a point where you're actually responding to office actions, definitely seek out an attorney. It'll save you a lot of time. Depending on what you're trying to submit to the USPTO, you do run the possibility of committing perjury. So that's just something to have on your radar. And the other one that I would say also is if you're creating pipes for tobacco use, that is allowed. There's actually a specific category for it. And I've seen some of the businesses that I've mentioned before who are some of the, I think, more established pipe makers even file just under glass art, glass sculpture. That I think, and I would encourage people to consider doing that.
Yes, yeah, for sure. Yeah, so they don't require necessarily specificities on what you're doing. It's just kind of a general, generic thing.
The more specific you are in what you do, the better protection you have. Because the more detailed of a description of what you do, if there is the possibility of someone infringing on you, if it's general and it looks like what they're doing is close to what you're doing, but it's not, it's harder to say, well, this is specifically what I do. They're doing this specific act. Clearly, there's infringement.
Yep.
When you speak in generalities, there's a lot more room to argue that, well, we're not actually doing the same thing. So, and if you're too general on the filing, you will get rejected by the USPTO just on that basis too.
Okay, cool. Good to know.
So, and then that moves us into the last area, special concerns for pipe makers. This is an interesting one. It touches on some of what we talked about in the last episode too, just because you do now have states that have amended their laws that the sale of accessories or cannabis accessories or modifications of criminal code where drug paraphernalia is no longer defined as utensils used for ingesting cannabis. So we're talking about Colorado, Washington, Alaska, and Oregon. You might want to start marketing your product where you're like, hey, look at people can legally consume cannabis, so this is what I'm making it for. That's still federally illegal. Mm-hmm. Even though if someone was caught, and I wouldn't be even caught, if they were stopped and they had cannabis on them and they had a pipe that you made, that's not illegal anymore if they're within the range and age and all for having the cannabis. So it's an interesting time in that regard because I could probably, or you could file for a state trademark in those areas saying I make cannabis pipes, because there's both state and federal trademarks. And I would assume from talking to the really nice lady in the state of Washington at the trademark office that you would have one granted on that basis. So it's really confusing where now you have a state trademark that's registered with the state of Washington. If there's infringement, you still can't bring that. And if you've registered it for a cannabis pipe, you can't bring that in federal court for infringement because the federal court system still wouldn't acknowledge that you have a valid trademark.
Right. Huh.
So there's a big disconnection in that. I actually just read a really great article from International Trademark Association talking about how there's just a very big disconnect right now between the state and federal laws, where it's been fairly harmonious before because most states have modeled their trademark offices off of the federal system. So
yeah, it's interesting. And then on that same note too, so if you do get the trademark in a legal state, you shouldn't or cannot, under recommendation, I guess, by whoever out there, that you shouldn't advertise in states where it's illegal recreationally.
I would, if you are in your business model, decide to pursue a state trademark where you're saying you're making these pipes for cannabis consumption, and that is the mark you register. I would not sell your work in any other state besides that state or states that were compliant. That is my thoughts. That's just my opinion. Other people might disagree with that. Just because you've identified that you are creating these pipes for cannabis consumption, and the definition of paraphernalia, one of the factors for testing it is what is the intent of the creator? What did they make it for? Now, if you created it for an artistic purpose or an expression, or you want something beautiful to sit on a shelf, or you created it for the intent to use it for tobacco, you arguably have passed that factor for, is this paraphernalia? You're positive it's not. But if you have a registered trademark and I was going to prosecute you, and you say, well, I'm selling cannabis pipes in Washington, but in Wyoming, these are tobacco pipes, I'd ask, well, clarify, show me why they're different. You've registered and you've shown me your intent here. And let alone now you've also crossed state lines potentially with your shipping. Explain to me how it's one thing here and another thing somewhere else, because you had the volitional intent to register a trademark in the state of Washington. Why does that change now? You can't, it would be, for a really watered down sense, trying to double dip on what this is. It's like, oh, over here it's one thing, and now that we're in a different area, it's totally something different. Courts don't buy into that so easily. So that's something to consider. So I think if I was, I would be a little bit leery in registering state trademarks. I think there's a definite benefit for cannabis businesses, but I think for the glass industry right now, I would be a little bit hesitant to just identify in that regard.
Yeah, for sure. Yeah, so much gray area still.
Yeah. Well, most of the gray area is just that this is illegal, and
it's pretty big.
Right. Paraphernalia is still an issue. The international borders are still very much an issue if you are trying to ship internationally, or if you're a glass shop and you're trying to receive packages internationally. That's still, the U.S. customs are a big deal, and they will hold up packages, and it happens all the time. So
yeah, it's unfortunate.
Yeah.
Well, awesome, man. That was good stuff. It's hope everybody kind of catches on and takes notes and write this stuff down, and really think about what they're doing in their work and how they're creating it and who they're creating it for. Because as cutesy as we want to be with our work nowadays, sometimes it's not always the best thing to be super cutesy and go off these other ideas of other companies out there that are making stuff. But I guess with the trade. Oh, go on. I didn't hear about
you actually just reminded me. That was the last point that I wanted to say for special concerns for pipe trademarks in the pipe industry. The Instagram accounts that you're using, depending on the products you're using, your hashtags, if it is a trademark, are going to lead businesses to find you. And if you are infringing on their trademark, you are going to get a cease and desist letter based on that. There's a number of occurrences that I'm familiar with in the industry that have had this. I think one of the ones that comes to mind most recently was seeing the discussion about lava lamps.
Oh, yeah.
And lava lamps seem fairly generic to us because we're like, oh, yeah, a lava lamp. That's actually a trademark. And I know that there was a glass maker who is making lava lamps, and I think they're now called something like Party Lamp, some other name. But it's being aware of, if you are recreating things that already exist in the world, be cautious about using things that are actually a trademark, because I don't think we've seen one to fruition yet, but actually having a lawsuit on this basis, especially from an established company, would most likely devastate most glass blowers. Then just because this hasn't been an issue for the last 5 years as much doesn't mean it's not going to be an issue in the next 5 years. I think anyone who's living on the idea, well, but I've done this forever, that is not a good legal way to live your life. Just have that on the radar, especially if you are in the habit of recreating things that already exist, or that's part of your business model or your product line. Just be very aware of what you're calling those things, and especially how you're marketing yourself on Instagram.
Heck yeah. And when we get into the talking, future episodes talking about copyright and stuff, I definitely want to talk about parody, that kind of ideas, because there's a lot of parody going on out in the industry as well. But the parody is like kind of a fine line it's been walking.
Oh, parody is a fine line too, where especially when you add in sales after the fact, like you really have to have all of that organized. Thinking about like Scary Movie and movies like that, where it's the entire basis of it is parody. It's you just got there's a lot to that. No, and I look forward to it. I think the copyright episode will be really interesting because I think there is a lot of room for copyright to apply to the glass industry in the future. We just need a federal shift for one, and then two, we just need some glass artists who try to register their art.
Yeah.
And I hope I would like to see that happen. So.
Me too.
Yeah.
Maybe
so
I'll take that jump one day.
I look forward to, and I need to do more research on that too, because I mean, I have asked this to plenty of attorneys who have far more experience than I do, and I just keep getting scratched heads, usually from attorneys being like, I didn't know that this existed. And then, are you serious? They're selling pipes for that amount of money? And I'm like, yes, that's very much real and consistent. And then, well, yeah, I mean, that's a work of art, so that should be protectable. I don't know is consistently the answer that I get. So I think that's something to be investigated a lot more.
Yeah, I agree. Hell yeah.
So.
Well, once again, brother, thank you so much again for your time, and it's an honor to have you on again, and I'm looking forward to more episodes and giving everybody some insights to ways we got to really take care of ourselves as we grow as a real industry every year.
Yeah, and I thank you again for having me. I really appreciate it. I think the best practices for this industry is essential for the industry to go forward and especially to grow in a positive way. Just even in the last 3 years, I've seen so much growth and adaptation to what I would say is more traditional business practices that I think just having that awareness, especially for people who are just getting into the glass industry, know what you're doing beforehand, because it can save you a lot of time and a lot of problems down the road. I think, and this is not at my shameless plug part yet, which I'm going to do. But try to find attorneys you can work with. A lot of people I talk to, especially if they're, depending on the cultural background they have, they're only used to the idea of talking to an attorney if there was a criminal issue. And more, you can prevent a lot of problems if you talk to and get good advice before you're at that point, because otherwise it's just picking up pieces and trying to prevent, either a fine or a jail sentence. But you can potentially prevent a lot of that if you can find someone that you trust and has good representation beforehand. So, and I'm not saying me. What I'm saying is just find some assistance. So
yeah.
But now that being said, now I am going to do my shameless plug. So my office is the law office of Luke S. Zimerman, APC. I am a California licensed attorney. My phone number from my office is 415-230-5308. And I work out of San Francisco. My website is lawofficelsz.com. If any of you happen to be in the Oakland area next Tuesday and you're affiliated with Oaksterdam, if you're an alumni, I'm going to be teaching the first ever intellectual property for the cannabis industry course on the 15th, which I'm really excited about. So if you're in the area, please come check that out. And if you're at the Emerald Cup, I'm going to be in attendance there, but not speaking. I love meeting new people and people who are connected to the industry. So, and then my final disclaimer, no one who is hearing this is my client. This has not been legal advice. This has just been my interpretation of some of the laws. Do not take any actions based off of what you've heard in this interview or in this podcast. if you have anything that you feel like really does pertain to you or your business or you personally, seek out representation from a licensed attorney in your state. That is paramount.
Beautiful.
So,
hell yeah.
Yeah. Thank you, Wise Guy, for having me today. I really appreciate it. And it's, it's great reaching out to your fans and being able to touch people. I think you're doing a really great service for the entire industry, and I really respect what you do.
Thanks, man. I appreciate that. Hell yeah. And again, guys, you can find his banner on all of our newsletters we put out, and also the website at wiseguyradio.com. The bottom of the website, his banner's on there. So if you guys have questions or need help with anything, definitely go on there and hook him up.
So, okay.
Hell yeah.
Well, I need to run and do some errands, but it's been great talking to you, and I look forward to the next time we do this.
Right on, Brand. Take it easy, dude.
Okay, take care.
All right, brother. Bye-bye. Thank you guys so much for listening to this episode of the Wise Guy Radio Show. If you have any questions, comments, or remarks, please leave them in the show notes page area where it says comments. We'll see you soon. Have a wise night.
You're listening